The French Data Protection Authority is probably the EU's most active in enforcing the e-privacy directive, and this week published some recommendations for mobile app developers, publishers, and other actors, and also announced an enforcement sweep in this sector coming up next spring. So in this edition of the Privacy Corner with me, Robert Bateman, I'll be looking at the very extensive and really quite useful guidelines from the CNIL. The UK DPA has taken its most significant action yet on cookies. Spoiler alert, it is, of course, a reprimand. And there is a very interesting new EU Advocate General opinion about what information controllers should provide regarding automated decision making. So I'll take a look at that. Before we begin, though, Privado AI, the very kind sponsors of these videos and my newsletter, are announcing a new collaboration with Nishant Bajara, who is a privacy engineering pioneer. He's worked at Meta, Google, Uber, and other important tech platforms. And they are launching a privacy engineering center of excellence to help people bridge the gap between engineering and legal departments and bake privacy into their applications. So please do take a look at that. The Privacy Engineering Center of Excellence. I'll leave a link in the newsletter. Firstly, then, the CNIL recommendations on mobile apps. These apply to application publishers, developers, suppliers of SDKs, software development kits, operating systems, and app store providers. Very long set of recommendations with some very interesting stuff. And a reminder, the French Data Protection Act incorporates the e-privacy directive in such a way that they can issue some pretty hefty fines for non-compliance, unlike other countries where the e-privacy directive fines are capped. So the most interesting part of these recommendations for me is how the CNIL talks us through the different roles occupied by these different actors, whether they are joint controllers, or processors in different circumstances. I think that some mobile app people, actors, companies are likely joint controllers under these recommendations where they would prefer to be processors. So do read them very carefully. Each of these different actors can play different roles depending on the purposes and their determination of them. And there are also some very detailed recommendations on putting data maps in place, making sure you know which actors have access to data generated by the app, and also being careful about the read-write operations under the e-privacy directive. What are you reading from the user's device? What are you placing on the user's device via the mobile app? So data protection by design, security by design, there are some pretty basic recommendations in here, but a really good level of detail about what is expected in France from mobile app developers and publishers and so on. Do read these recommendations. They are actually really quite extensive and comprehensive. And remember, mobile app enforcement sweep coming up next spring in France. The ICO has taken what I am fairly confident is its most significant action on cookies to date. This is a reprimand against SkyBet and Gaming, trading name of Bon Terre. And they were setting cookies on their website without consent. So before users had had a chance to accept or reject cookies via the cookie banner, SkyBetting was allegedly setting them on the device. Now, they sorted this out very quickly, within a day of the ICO notifying them that this was a problem. And that partly explains the leniency of the penalty, or non-penalty, the reprimand. Now, this was under the UK GDPR, specifically Articles 5.1a, which is the lawfulness, fairness, and transparency principle, 6.1a, which is the lawful basis of consent, and 7.1, which requires the controller to demonstrate that they have the consent of the data subject. Interestingly, this was not done under PECA, the UK's implementation of the e-privacy directive, and I'm not really sure why. I'll come back to that shortly. There are a couple of mitigating factors here that led to this more lenient penalty against SkyBetting. They took steps to avoid targeting problem gamblers or people with gambling addiction with ads. So the campaign group that lodged this complaint was concerned about targeting of vulnerable people. Sky Betting does appear to have taken steps to the satisfaction of the commissioner to prevent that. So things like profiling people, basically, to see if they are declared problem gamblers or have a self-exclusion agreement. Interaction with other laws here, as well as data protection. They also had contractual and technical limitations on their ad tech providers, so to avoid them seeing, apparently, whether the user had interacted with a gambling website. But as noted, no mention of PECA here. Now, the e-privacy directive, as you'll know, is the primary law requiring controllers or website operators to get consent for non-essential cookies. And that appears to be what Sky Betting has failed to do. So I am quite surprised that they've gone down the GDPR route here. Perhaps it's to do with the enforcement regime and the availability of reprimands or whatnot. The press release also provides some interesting insights into the ICO's other significant cookie campaign, which is writing to popular websites asking them to amend their cookie banners. They say that 99 out of the top 100 websites are now either offering a meaningful choice over advertising cookies or making improvements to how they get people's consent. Only one remains that has ignored the commissioner, allegedly so far, which is a gossip website called Tattle Life. Now, this is interesting because UK listeners will know that many of these websites, or some of them at least, have adopted consent or pay policies since getting the ICO's letter. And this statement suggests that the ICO either considers consent or pay to be a meaningful choice or an improvement over the kind of second layer of the cookie banner opt-out process they were doing before. The ICO is currently consulting on whether consent or pay is legal to determine its legal position as a regulator, interestingly, and this suggests that they are going to be okay with consent or pay. Could be clumsy wording, but logically, it suggests that they consider it an improvement over the opting out for free option, which is interesting because I would suggest that paying to opt out is more burdensome than clicking an extra settings option on the cookie banner, but there we are. Finally, the EU Advocate General Richard de la Tour has issued an opinion on an interesting case involving automated decision-making. So as you'll probably know, automated decision-making is prohibited in certain circumstances under Article 22 of the GDPR, and the data subject is entitled to meaningful information about the logic involved in such decisions under Article 15(1)(h). So this opinion is all about how much information to give and what type of information data subjects are entitled to about automated decision making. The case involves a data subject known as CK, who applied for a mobile phone contract. They underwent a credit check by Dun and Bradstreet Austria, DNB, and asked for meaningful information about that decision. Now, the decision was that they should not be allowed to have the contract, but the information DNB provided, somewhat reluctantly, suggested that they should have been allowed the contract because their credit check came up pretty good. So the question is, the main question, should the data subject be able to see the kind of causal link between the decision making and the decision? The court, the Advocate General, heard from an expert who suggested some very extensive information should be provided in this regard, including mathematical formula underpinning the algorithm involved in these decisions. He doesn't go that far. He says that as long as the information is clear, meaningful, comprehensive, and easily understood and concise, then it's enough. You don't have to give the data subject maths. They should be okay with just a decent, clear explanation of what's going on. The opinion also covers trade secrets. So one issue with AI companies is that if they give too much information about their algorithms, they might be telling competitors how they do stuff, which they are very reluctant to do. If the disclosure to the data subject would require the disclosure of trade secrets or information about other people, then the Advocate General thinks it should be submitted to a data protection authority or a court first, who will decide whether to divulge those trade secrets to the data subject. Now, I think some AI companies might be pretty nervous about leaving their trade secrets in the hands of a data protection authority, particularly some of the more data subject friendly authorities, for example, in Norway or Austria, where this case originates. So, very interesting development. We'll see what the full court hearing says. Remember, this is just an Advocate General opinion, but definitely one to watch if you are involved in or you have clients involved in automated decision making. So that's all from me this week. Thanks so much for your time and support and for bearing with me over a short break from the Privacy Corner. Thank you as well to Privado AI for supporting the show. Please do check out their Centre of Excellence, which there is a link to in the newsletter. See you next time.